Ready, Your Honor. Robert J. Kill on behalf of Nick Mercer. Nick, would you state your name for the record, please?
Nicholas Edward Mercer.
Judge, in this matter, I had a chance to speak with Nick. We believe that if an exam were held, you would bind this matter over. That being said, and Nicholas agrees that we'd like to waive up to circuit court.
Is that correct, sir?
That's I mean, there's actually like more to it. I mean, that's not necessarily the whole thing is I've been here for 6 months.
Nicholas, hold on a second. You've got 3 matters up in court already represented by Stewart.
No, I got 4 matters.
We're going to get this matter up there for a global resolution.
Yeah, correct.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that this offense alleged was committed and that you committed it.
Right. Yes, sir.
All right. You understand you'll not have that hearing and you'll proceed it to circuit court and join your other cases.
Right. Yep.
Okay. People also waive their right?
We do.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Killowald.
Your Honor, acknowledge you received the information, waive its reading. My client will stand mute. My client believes he has a pretrial on July 5th. Is that true, Nicholas?
Yes.
Is it possible?
Defendant having waived formal reading, standing mute, court will enter not guilty plea. What pretrial date do you have on this?
12. I don't have it.
We have the 12th. We do not have the 5th.
Judge,
what?
I'm sorry.
I can do it one of 2 ways. I don't think Judge Conlon will have a problem if I set this for the 5th. I don't know if the file will get down there. It usually is, it should, but it's usually what I do is I set it for the 12th and then you contact their office and they make sure that it gets on for that day.
Judge, let's do that, Judge. I'm going by what my client's saying. Let's set it for the 12th and I will call the judge.
Intro. Welcome back, everyone. Today's courtroom drama is intense. Judge Boyd doesn't hold back as she confronts a defendant who's made some questionable life choices. Let's take a closer look at how the judge takes control of the situation with tough love. The reality check. The defendant, Virginia Ruiz, is on the hot seat, and the judge is ready to give her a wake-up call. The conversation takes a sharp turn when Ruiz admits she's going to test positive for marijuana. Judge Boyd immediately fires back with a thought-provoking question. Would you trust a babysitter who smokes weed and is upfront about it? Ruiz hesitates, but the judge isn't done. She presses, asking if she would leave her kids with someone who's high. The answer is a resounding no. That's when the judge hits Ruiz with the truth. You're the Mary Poppins who's positive for marijuana, no job, and relying on taxpayers.
Ready, Judge. Torshell Feaster, Assistant Public Defender, on behalf of Mr. Chauncey Hyman. Mr. Hyman, please state your name for the record.
Chauncey Maurice Hyman.
Thank you, Judge.
Okay, what are we doing?
I've actually had to speak to Ms. Blanche on this matter and to Mr. Hyman. My understanding is that this matter had previously been set for exam, and this is a recharge. Mr. Hyman,
Yes.
you to set this matter for exam again, please, at the court's earliest convenience.
Preliminary examination will be set for July 11th,
Thank you, Judge.
2023, 9 a.m. That is before Judge Burke.
Judge,
Well, who was it before?
Valvo, Judge.
It was before Judge Valvo?
Yes, Judge.
All right, it stays with Judge Valvo, so that makes the preliminary examination the 18th
Thank you,
before
Judge.
Judge Valvo.
And I believe Mr. Hyman wanted me to address bond if you would entertain that.
Go ahead.
Thank you, Judge. As the court is aware, this matter was dismissed at exam. My understanding of talking to Mr. Hyman is that he is at risk of losing his apartment, a substantial financial loss, and he has no objection to being on tether or following any other of the court's rules. Should the court put him on tether, he was hoping Your Honor would consider a tether and under personal bond in this matter, Your Honor.
Response.
Judge, bond was addressed the first time it was written. Obviously, at the second arraignment, the
judge at the arraignment knew this was a rewrite. Our victim was there. She's terrified of the defendant. She could not appear in person. She tried to appear on Zoom. She was not allowed to. We're going to proceed on the case regardless if she's there or not. There is a possession by felon and a felony firearm attached. He pointed a semi-automatic pistol at her. It was loaded. He said, "You check these rounds." He had one round in the chamber. The hammer was back. The lethality on this case is concerning. So we ask that you don't change bond.
Anything else, Mr. Feaster?
No, Judge.
Motion for bond reduction is denied. Bond will continue as set.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Versus Michael Roberts.
Jessica Blanche, Perry, the people.
Ready, Judge. Torshell Feaster, Assistant Public Defender, on behalf of Mr. Michael Roberts. Mr. Roberts, please state your name for the record.
Michael Roberts.
Thank you, Judge. Mr. Roberts also has a couple cases up at Circuit Court. We adjourned those yesterday out to July the 12th. I am requesting that this matter go 2 weeks as well, potentially to the 13th if that fits the court schedule, so that we can see about trying to get this matter resolved. I did receive an offer from the people, and I do know Mr. Roberts is hoping for a bond. We're working on that in Circuit Court. If we're able to reach a resolution there on a bond, I'll reach out to Ms. Blanche to see if she'll consent to a stip. But at this time, I don't have an argument.
All right. You know, Mr. Feaster went about trying to pick his date. He didn't learn.
I thought I did it in a very nice way.
I think he realized after he did it. But if there's no objection, I'll turn it out to the July 13, 2023, 9 a.m.
Yeah.
Defendant's bond. Oh, I'm sorry, Ms. Blanche.
No, I'm fine with the adjournment, but I did want to address bond.
Okay. Go ahead.
Judge,
Go ahead.
He's been contacting the victim in the case, so I'm asking for you to revoke his jail phone call privileges. In fact, on phone conversations, he's told her not to show up to exam, that the case will get dismissed and dropped. So he's not supposed to be contacting her. I'm asking you to revoke his phone privileges.
I was there. Ms. Blanche did notify me about that this morning, Your Honor. I have not had a chance to speak to Mr. Roberts about that. If the court is inclined to restrict his phone privileges, I'd ask that the court restrict him and admonish him not to speak to the alleged victim in this matter, but not to restrict his total ability to make phone calls from the jail. And I will have a thorough and direct conversation with Mr. Roberts about contacting the complaining witness in this matter now that I'm aware of the allegation and what's happening, Your Honor.
Well, certainly I would review that on the 13th, but what it sounds to me like is that these are phone conversations that are, if true, would amount to some type of an obstruction of justice or witness intimidation or and the like, which is probably more problematic than the phone calls themselves. So I will adjourn us out to the 13th. Regarding his bond, his current bond is set at how much? I got 5,000 personal.
He's probably being held on the circuit court matter, Judge.
Yeah, I see a person.
Well, I'm going to do two things, at least pending the hearing, and I'll look at it again. The defendant's bond is going to increase based upon the representations to the court to amount of $10,000 cash surety bond. Defendant's phone privileges are hereby ordered revoked pending that hearing on the 13th and additional information provided to the court. Thank you.
The judge's mic drop. Judge Boyd doesn't mince words, laying out the reality. Ruiz is not supporting herself or her children, and she's depending on public assistance to get by. The judge calls out the fact that Ruiz isn't working, isn't receiving child support from the father, and is openly admitting to marijuana use. The tough question comes next. What does a good parent look like? A good parent is someone who can support their children, not someone who relies.
Okay.
I'll look at it again. And I'm going to warn you, sir, If I find that you may be trying to make calls through other devices or other people's accounts, I don't care what happens in circuit court while it's here, you certainly will not be getting out of that jail.
Okay,
Am I clear?
you're clear.
Thank you.
Yep.
Thank you, Judge.
People versus Beverly Tuttle.
Namesh Ganatra, First Assistant Prosecuting Attorney for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Tuttle. Ms. Tuttle, would you please state your name for the record?
Yes, ma'am. Beverly Tuttle.
Hey, what are we doing?
Good morning, sir.
Your Honor, we are asking for an adjournment. I did reach out to Mr. Ganatra regarding a potential resolution for this case. I would also like the opportunity to address bond.
Probable cause conference, July 13th, 2023, 9 a.m. Ask to bond.
Your Honor, it's my understanding from Ms. Tuttle that this is the only matter that is holding her in custody. I did have an opportunity. Let me start with, she did indicate that she has been awarded a Section 8 housing voucher. It is her belief that the voucher will be expiring in a few days, maybe as early as next week. She did have me reach out to her case manager at the Delusions Center, who's been working with her, who was able to confirm the housing voucher, as well as that it would be expiring soon. He did not know the exact date. He did also say he needed to speak to his supervisor before he could write a letter. I have not heard back from him. I plan on following up, but this housing would be a game changer for Ms. Tuttle. It's also my understanding from Ms. Tuttle that she has been working with her primary care physician out of Packard Health, who has referred her to behavioral services to get her back involved with mental health services. So she anticipates starting that upon her release as well, which would be for medication management and potentially also therapy.
Anything from the people?
Your Honor, she failed to appear to community corrections back in May. There was a report dated May 19th. And I think that coincided with a bench warrant for failure to appear at a PCC in May of this year. I score her guidelines at 5 to 23. She has prior felony convictions for custodial interference, kidnapping, larceny in a building, uttering and publishing, forgery, misdemeanor conviction for operating while high BAC. This incident involves her being in possession of a loaded firearm, also having cocaine in her possession when she came into contact with the Ann Arbor Police Department. If the court's inclined to release her, the people's concern would be that she have some type of testing in place to ensure sobriety.
And we've already tried that and it didn't work.
Yeah. May I address just a couple things? Mr. Ganatra did go through Ms. Tuttle's criminal history, which we'll acknowledge. But I do also want to say that up until fairly recently, she had 13 years of sobriety underneath her belt. This is a recent relapse. If you look at the dates of the convictions.
Okay to depend on others and to make poor choices. The judge's goal? To help Ruiz get her life together so her children can have a better future. Conclusion. This courtroom encounter was all about responsibility. Judge Boyd challenged Ruiz to step up and prove she can be the kind of parent her children need. It's a tough love moment, but one that might just be the push Ruiz needs to change her life. What do you think, folks? Was the judge too hard on Ruiz? Or did she deserve that reality check? Let us know your thoughts in the comments below. Intro. Welcome back, folks. You're about to witness a courtroom showdown that's all about tough love, accountability, and some serious life lessons. Judge Boyd doesn't pull any punches as she sets out a life-changing rehab plan for a defendant who's been living off the system and relying on marijuana. Let's dive in. The reality check. Virginia Ruiz is in the hot seat, And Judge Boyd's not playing around. The defendant admits she's going to test positive for marijuana, and that's when the judge hits her with a reality check. The bottom line, if you want to be a responsible parent, it's time to put down the weed and step up to the plate.
To you, Your Honor.
How did you come back into custody, Ms. Tuttle?
I had returned to Ann Arbor on the night I was arrested. I had been assaulted, and had.
So she didn't turn herself in. What else do you want to say to me,
Excuse
ma'am?
me, are you talking about original arrest or now that I'm in custody here?
I'm talking about on the bench warrant where you failed to appear for court and you failed to go to testing at community corrections.
First of all, sir, upon my original arraignment, when I was given the PR bond, I did show up at community corrections. When I went to community corrections upon my release, the form that they gave me to take to community corrections was empty. There was no indications of how I was supposed to be tested, what I was supposed to be tested for, or anything of that nature. The woman, I signed the sheet at community corrections. You can verify with them. I was there. I did show my ID. I did sign in. The woman that was at the desk sent me to 14-1. I went across the street. I went into 14-1. I talked to the two black ladies that were behind the window. I gave the one my paperwork. I was on borrowed time because I had a ride from someone else. She disappeared with my paperwork for like a half hour. And I kept asking if I could get my case number, if I could get my public defender's name. And there was no information that they could give to me. And I had to leave. All of my court paperwork was left there at 14-1. I didn't have my case number, a public defender's name, nothing. And I did make multiple attempts to try to make contact to get this information. But I did show up to community corrections as ordered with a blank piece of paper, and they said there was nothing they could do for me. Also, at my original arraignment for this case, the magistrate told me, because I explained to her, my disability is in final pending stages. And I told her I did not have the money to pay for the testing, and she told me that they should be able to work out something with me. When I went to community corrections, they told me that unless I could pay for it at the time of testing, there was nothing they could do for me.
Motion for bond reduction denied. Bond will continue.
Your Honor,
Thank you.
can I just clarify one thing, Your Honor?
Oh,
Yes.
There was a representation made about 13 years sobriety for her. Is that what I heard?
That is what Ms. Tuttle relayed.
Your Honor, there's a conviction from February 2015 for operating with high BAC. The date of offense was November of 2014. That was in 14B District Court.
Yeah, I will say that Ms. Gaines can only represent to the court what her client represents, and that is just one of many misrepresentations that have been made. So